Welcome to the Explainer, everyone. Look, if you're a first-year law student staring down the barrel of your contracts final right now, and you're kind of wondering how a simple yes can possibly be this complicated, well, you're in the right place. Consider this your ultimate survival guide to mastering contract acceptance. But hey, before we totally unravel the mysteries of offer and acceptance, I really need you to do something crucial for us. Hit that like button on this explainer and subscribe to our channel. Seriously, it's the very first step to conquering those 1L exams and making sure you never miss one of our legal deep dives. Okay, let's dive into this. Here is our roadmap for today. We're going to cover the power of assent, the common law mirror image rule, the UCC battle of the forms, the mailbox rule, and finally, acceptance by conduct.
Starting right off with Section 1, the power of assent.
So what is acceptance, really? It's that absolutely critical yes that basically breathes life into a contract. Legally speaking, it's the offeree's manifestation of assent. That just means there has to be a clear outward sign that they agree to the deal. The absolutely crucial thing to remember here is that the offerer, the person making the offer, literally empowers the offeree to create the contract. They hold the cards. And remember, only the specific person to whom the offer is made has the power to accept it. A random third party can't just swoop in and say, I accept. Moving right along to Section 2, common law and the mirror image rule. Okay, so under traditional common law, things are strict, really strict. We have what's known as the mirror image rule. This means your acceptance has to be an exact, absolute, unequivocal, and completely unconditional agreement to every single term of the offer. If your response varies the terms in literally any way, or maybe introduces a new condition, bam, the deal's dead. It operates instantly as a rejection of the original offer and acts as a counteroffer instead. Any variation kills the original deal. Let's look at the classic case of Pohl versus Brunswick to see this in action. The facts are pretty straightforward. Pohl offered to sell some rubber. Brunswick responded with an order form that perfectly matched the terms, right? But they added just a tiny little bit of boilerplate text that said, promptly acknowledge. So the issue becomes, does that minor new condition act as a valid acceptance? The court said, no way. Because it required prompt acknowledgement, it didn't perfectly mirror the offer. And since Pohl never formally accepted that new counteroffer, no contract was ever formed.
All right, Section 3, the UCC and the infamous battle of the forms.
So let's explicitly contrast these two worlds. While common law demands that strict perfect match, UCC Section 2-207, which everyone calls the battle of the forms, is way more flexible. The drafters basically woke up and realized that in the real world, businesses selling goods just swap pre-printed purchase orders all day long without reading the fine print. So, for the sale of goods under Article 2, the UCC actually abandons those strict formalities. Instead, it focuses on whether the parties objectively appeared to intend a contract. A definite and seasonable acceptance can actually form a contract, even if it contains different or additional terms. Now, navigating this battle requires a bit of a step-by-step approach. You start with the offer, right? Then you look at the acceptance. Ask yourself, does it have new or different terms? If it does, you have to figure out if the acceptance was expressly conditional on those exact new terms. If it wasn't, well, congratulations, you actually have a contract. And those new terms, they're just proposals. But if the acceptance is expressly conditional on the new terms, then hold your horses. You do not have a contract yet, at least not based on the writings alone. To really wrap our heads around this, let's talk about Dorton versus Collins and Aikman. Here, a carpet order was placed over the phone. The manufacturer then sent back an acknowledgement form, but it had a sneaky little arbitration clause hidden in the small print. It basically said acceptance was subject to all of the terms and conditions on the face and reverse side. So, the million-dollar issue. Does that arbitration clause become part of the actual contract? The court held that this vague language was not enough to make the acceptance expressly conditional. Therefore, a contract was formed anyway, and that arbitration clause was just treated as an additional term. Which naturally leads us to what exactly happens to those additional terms when both parties are merchants. For that, we look to UCC-2-207, subsection 2. The general rule is actually that those additional terms automatically become part of the contract. Kind of scary, right? But don't panic, there are 3 big exceptions where new terms get blocked. First, if the original offer explicitly limited acceptance strictly to its own terms. Second, if the new terms materially alter the offer, like say an arbitration clause that causes a huge surprise. Or third, if the offerer has already raised an objection to them. But what if the terms in the two forms don't just add something new, but they directly contradict each other? Listen up, because here is a massive bar exam insider tip. most jurisdictions apply what's called the knockout rule. Those conflicting terms literally just knock each other out completely. They both drop entirely out of the contract, and the court will just patch up the holes using default UCC gap filler provisions, things like reasonable delivery times or standard implied warranties. Next up, Section 4, the Mailbox Rule. Okay, this is a highly counterintuitive rule, so you need to lock it into your memory right now. The Mailbox Rule states that an acceptance is effective the exact moment it is properly dispatched. Note what I said there, dispatched, not when it's received. As long as you use a reasonable method of delivery and it's properly addressed and stamped, that contract springs into existence the literal second it leaves the offeree's hands and enters the postal system. But there's always a trap, right? And the trap here is the exceptions. Misapplying this rule on an exam is a super common pitfall. The Mailbox Rule does not apply if the master of the offer explicitly says something like, "Hey, your acceptance is not effective until I actually receive it." It also generally doesn't apply to option contracts, which usually require actual receipt. And if the offeree gets cold feet, sends a rejection first, but then changes their mind and sends an acceptance, well, then it's just a foot race. Whichever one the offerer receives first is the one that controls the deal.
Finally, we hit Section 5, Acceptance by Conduct.
Under the UCC, if an offer asks for prompt shipment, a seller can accept the deal either by promising to ship the goods or by just shipping them. But here is a wild trap for you. What if a buyer orders blue widgets and the seller accidentally ships red widgets? Shipping non-conforming goods is simultaneously an acceptance of the contract and a breach of that very same contract. Wild, right? Now, the only exception here is if the seller seasonably notifies the buyer that the wrong goods are being sent merely as an accommodation, basically saying, "Hey, I don't have blue, here's red as a favor, take it or leave it." In that specific case, it operates as a counteroffer, not a breach.
We also really need to touch on silence. The general overriding rule is that silence is not acceptance. You can't just say, "If I don't hear from you, we have a deal." But yes, there are exceptions. Silence binds you if you happily take the benefit of offered services when you had a perfectly reasonable opportunity to reject them, or if previous dealings or established trade customs have created a totally reasonable expectation that your silence means, yes, go ahead and keep shipping. Just picture a supplier who has sent you goods every single month for 5 years without needing a new written order each time.
So here is your biggest takeaway for today. Before you do literally any legal analysis on an exam, you absolutely must categorize your legal framework. Are you dealing with a real estate or service contract under the strict common law mirror image rule? Or are you dealing with the sale of goods under the UCC's flexible battle of the forms? Categorize first, always, then analyze. I'm going to leave you with a quick hypothetical to test your recall on what we just covered. If your supplier receives your purchase order, stays completely silent, but just goes ahead and ships the exact goods you asked for, is that a valid acceptance? Think about it. Based on what we just discussed about conduct under the UCC, you should absolutely know that the answer is a resounding yes. Actions speak volumes.
And that brings us to the end of the explainer. Keep surviving 1L, everyone. It's tough, but you absolutely got this. Do not forget to like this explainer and hit that subscribe button for more highly structured, straight-to-the-point legal deep dives. Catch you all next time.